In 1973, the Oregon State Legislature passed the Oregon Land Use Act to protect farm and forest land from encroaching development. Thousands of property owners suffered enormous losses to their property value as a result of the new regulations. After 30 years of litigation, Measure 37 granted those people a legal right to compensation for their losses. Each county had the option to either pay monetary restitution or issue waivers allowing claimants to use their property as it was originally zoned when they acquired it. There were so many claims, the state feared the goals of the Land Use Act would be compromised. Last year, Measure 37 was effectively repealed by the passage of Measure 49, and all waivers previously issued under Measure 37 were declared to be null and void. In Jackson County, 22 claimants decided to challenge the legality of revoking waivers that had already been granted and duly recorded in the deeds to their property. On November 12, 2008, U.S. District Court Judge Owen Panner ruled that Measure 37 waivers are constitutionally protected contracts that could not be legislated away by the passage of Measure 49. We tried to reach Jackson County Commissioners for comment, but Commissioner David Gilmore said the county could not comment on the case at this time, pending further litigation.
The history of this thing is that back in the 70s, with the advent of comprehensive statewide land use regulation out of Salem, the counties were told that they had to adopt certain land use standards and that they would be required by the state to adopt ordinances to that effect. And the counties fought it. The counties did not want those regulations. They went to court, they fought, they lost, and they were compelled to adopt these regulations. And that's how things sat for 20 some odd years. Well, then the people of Oregon woke up as to what exactly this was costing the economy and the people of Oregon. And lo and behold, they passed Measure 37. And that said very simply, you can do this, but if it's going to affect so-and-so's value, you have to pay him for the damage that you have done. Well, the counties were kind of happy with that because in the same piece of legislation, it gave the counties the option to avoid paying that money by simply waiving whatever statute was creating the problem. So, the counties vigorously pursued exactly the process that was required. Claims came in, they investigated the claims, they had an adjudication of the validity of the claims, and they made a judgment. And then, to protect themselves from having to pay the liability they figured out that they owed this claimant, they waived. And they did that for a couple of years. Well, then the state came along with Measure 49 and said, guess what, counties? We're taking away your authority to grant those waivers. Okay. At the same time, they promised to the counties that the liability to pay the damages would also go away. And we got involved, and we went to court, and we established the state could not make the liability go away. The county is left on the hook, and we have Richard Whitman saying, you cannot waive. You have to go forward. So what does that leave them?
The state was a party in that case because the county brought them in, and the state moved to dismiss to get out of the case because they said they shouldn't be in the case, and the federal court agreed and said the state doesn't have a dog in this fight. So now the state doesn't have a dog in the fight, but yet they're trying to interfere with a contract and a judgment that our clients have, and we think that they're going to be a little upset about what they've done because I think it's going to have severe ramifications to the state of Oregon.
Our whole position is the county should be fighting the state. There's an issue of indemnification here. They're the agent did what the principal directed, and the agent is left with the liability. And I don't think that's right. But politically, getting the counties to do that is a lot more difficult than it seems.
There's an analogy running around on YouTube, and it's called a little smart penguin. And there's a series of killer sharks trying to get this little penguin, and he's jumping around. You can go on YouTube and see it. And he's jumping around, and these killer whales are after this penguin. And it's about these people watching this smart little penguin. The smart little penguin jumps in the boat. And we're sort of looking for the boat. We feel like that little penguin.
Citizens for Constitutional Fairness was conceived in Bob Robertson's office one day because it was obvious that we were going to have to start getting into litigation after the passage of Measure 49, and we should probably form a nonprofit organization to develop a network among the various people that had claims. Kind of slim and none were the options that you had under Measure 49 compared to what people had gotten with the passage of Measure 37. So it boiled down to the fact that most people who had the Measure 37 claims in Jackson County were not going to get hardly any relief under Measure 49.
There's a lot of criticism of Measure 37 claimants as being greedy and the wealthy developers here to rape and pillage poor Oregon. And I have dealt with, at this point, maybe 100 different applicants, and that is not how you would characterize them. By and large, these people are elderly people who have, for their lives, invested in the land and nurtured the land, and in an economic situation where it's just not viable to continue working a losing proposition, would simply like to sell and save their retirement.
It's one of the most important cases of our life because of the hope for relief that it gives so many people that have waited so long. 40 years. Most of these people have owned these properties 30 and 40 years.
I've been here for over 70 plus years on this farm, and I hope to stay on this farm until I'm ready to depart. My grandfather bought this farm in 1909, so next year in 2009 it'll be 100 years that the family has lived on this farm. I'm the third generation and my son is the fourth generation on this place. My grandfather farmed with horses, cut hay with the old sickle, and my father then, we had to leave here for a few years because the Army took this away from us in July of 1941. About 6 months later they paid us, and I think they gave us about $1 an acre. But then in 1948 we were able to buy it back, and at that time there was no homes on the place. Our houses and the barns, the fences, the gates, everything was taken away from us. The wells were destroyed. We had foxholes in our field. We had barbed wire. We had live ammo.
I'm Kenneth's son, and I've lived here also pretty much most of my life, and I'm one of the only few of the family that's still actually farming. You know, it's too bad that the state won't allow us to do anything as far as, you know, dividing the property up, and it's pretty much a hardship on the family. I mean, farming's hard enough as it is, and if you can't do anything extra to help to subsidize your income, like selling off a little property here and there, basically that was how my grandparents were able to stay on here as long as they could, by selling off some of the land so it would help to subsidize their farming. And now it's come to a halt where we just can't do anything to make any extra money.
When they passed Senate 100, my father could not sell any more land. He had sold about 3 or 4 properties before that time. Measure 37, when we put an application in for that, and it was passed by the county. And then they stopped it when Measure 49 came along, but we couldn't divide it. We're waiting to hear from the county commissioners to see what they're going to do at the county level. And as far as the federal government, they have passed the law now that we can do it. So it's a matter of time now, and I hope that we can get started. We don't have much time left, none of us. It's not easy to say goodbye to a place that you have lived for 100 years. I mean, been in the family for 100 years. I'm not 100 years old yet, don't take me wrong. But I don't know what I will do if I have to leave, and I just hope that the county and the lawyers that we have working for us here will be able to persuade the people and to see how important it is to be able to let us who have lived here all of our lives sell a little of the property.
If we can't do something, I'm going to have to move to town and find another job. So
I feel like if I have to leave this place, my days are numbered. I just don't want to move to town. I don't want to leave the place because it's home to me, and it would just be like me moving to China or someplace from here now. I couldn't make it.
When I purchased the property back in 1967, of course that was prior to most land use planning laws and regulations as we know them today, and this land was all zoned open space development with 5-acre minimum lot size requirement, and now, today, it's been rezoned as of 1980 into WR, which is Woodland Resource, 20-acre minimum parcel size, which means that you have to have 20 acres in order to build a home. And then shortly after the 1980, it was overlaid with other requirements and zones, which now leave it as a 80-acre minimum. In order to build one home, you have to have 80 acres of land. You know, back in those days, I don't think anyone really realized what land use planning was or what it was going to become even. And most of us just thought we could wait until later, develop our property at the time that we could afford it. It would be wonderful to think that as I grow older and I'm now in retirement, that I wouldn't have to leave my property and sell my home, that perhaps I would be able to develop a lot or two and secure some kind of positive retirement. When Measure 37 passed, that was like a ray of hope in a very dismal situation. We were very discouraged about possibilities for the future, and that gave us some hope that we might be able to have our property rights back. We might be able to do some development. This property is not farmland, it's certainly not timberland, and we knew that the best use for this land was always for small home sites. Under Measure 37, I had applied through the county and the state and received my waivers for 8 additional lots, 5-acre minimum size, and was very happy about that, and had proceeded with one small partition for 2 5-acre lots through Jackson County, and had actually completed that and spent a fair sum of money doing that. However, when 49 passed, we were completely disenfranchised. Even though 49 was touted as a way to fix 37, it really gutted 37. The amount of lots that you're going to get, the number of lots, are so small compared to what most of us had already received approval for with our waivers that it's very disappointing. I was very, very excited when Judge Panner made the positive ruling that he did. I have never understood how the county or the state could give you approval for land divisions and then rescind that without, again, any kind of compensation. It always seemed wrong to me, and I was very, very gratified when Judge Panner agreed with us. That decision again has made people throughout the county hopeful. And we're talking about people who've had their property a long time. Most of us have lived on the property 20, 30, 40 years. In fact, anybody who's owned after 1980 is really not going to have a lot of benefit from 37. So it's the older people who've had their land for a long time that are going to see any benefit. I always want to remain hopeful that we can fix our situation here in Oregon and help our rural landowners be able to use their property for the right things and get their property rights back.